Do you
typically
find
see.
that you see more spousal maintenance in higher income
Yes.
situations?
Yes.
Okay.
By far, because they have the one of the things that you look at with spousal is one party's need. So after working to their capacity, how much are they short each month, and then the other person's ability to pay. And if you're a high wage earner, it's usually not a problem to be able to pay a spousal maintenance obligation. What we really duke it out over is budgets. What's a reasonable budget?
Because that's a little bit subjective, right?
Yeah, very subjective. Do you really need $800 per month in groceries? Yes, I have.
Cable TV.
Yes, all that kind of
vacations,
stuff. Vacations. Right, vacations. And that's where you kick into the standard of living. Well, did you take a vacation, to Europe every year that you were married? Yes. Well, that's part of your standard of living, so it's okay to have that in your budget. If all of a sudden, I had one colleague, and she had a case where suddenly the one spouse who was seeking spousal maintenance had a trainer for $1,000 a month.
Yeah.
Right. Never had a trainer during the marriage.
Maybe that's why they got divorced.
Yeah. Right. Yeah. Right. Exactly. So, but trying to kind of up the budget to, to get more spousal maintenance. But yeah. So at trial, what you'll do is you spend a good deal of time, showing credit card statements that reflect, yes, this is true. We actually spent this much on entertainment or food or whatever it might be, or bank statements or whatever supports that, what the costs were, because you're just showing the evidence to the judge. When you ask for award of spousal maintenance, I'm not making this up, right? Like this is really what I need, and here's our historical spending.
And you have to produce all that information, I'm assuming.
Yep, it's exhibits, right? We have to. Otherwise, the judge doesn't have a basis to award spousal maintenance. You want to make sure that they have all the information. And
that's something that's argued over quite a bit between the parties, like, well, no, you didn't spend that amount of money on that, or
yes,
you shouldn't be spending that amount of money.
Yes.
Okay.
Those are big. I mean, I think that as I said, I've tried more spousal maintenance cases than I have custody. And I think it's because people don't want to put their kids in the middle, or they don't want to risk having a bad custody order. Not that we don't have those as part of our cases, but those seem to settle, those issues settle as to custody and parenting time more than spousal does.
Money over children.
Yeah, they'll duke it out over money. And I just think, why are you paying me to do this, right? Like, just come to a resolution.
Well, don't sometimes you find that people spend a lot of money and a lot of time, and they basically come to the same resolution they would have had at the very beginning.
Right.
That they sort of tentatively agreed to, or the attorneys said, let's try this. Or...
Right. And I have learned over the years that used to bother me a lot, but in some cases you just have to let it play out, because one of the parties just won't accept, they might be stubborn, or they don't want to accept it, and then the case has to kind of go through the process, and then they land where they could have been, 6 months earlier. But sometimes they just have to do that. There's nothing that you can do.
Otherwise, they feel they came up short, so to speak.
Right.
If they didn't try.
Yeah, and then they flush out, and they can see, no, this is what, a evaluative mediator is suggesting, or the court has given us clues that this is how, the bench might be ruling on it, that sort of thing. But you sometimes see people who have to go through that process, and it does make you a little bit nutty, because you think, what a waste of time and money, right?
Yeah. Do the attorneys or the clients ever kind of call for a cooling off period much, or just say, you know what, this is out of control and we need to just cool down, or is it just kind of something that happens?
Now and again, sometimes you see people who reconcile, but usually if a case gets started, it keeps moving forward. Now and again, you'll see where people, that break that you're talking about, they'll put a case on inactive status. So it's been filed with the court, it's in process, but the parties agree, we want to take a break. We want to, a period of time to kind of think about what we want to do. And you can do that for up to a year, put it on inactive status. And after a year, you either have to tell the court, we're going to go forward with a divorce, or they'll dismiss it. And then if they go forward later, they'll have to start from scratch, basically.
What happens with, going back to the budget, what happens with children who are in private school? Is that a big issue as far as, if they have to keep paying for it, or one party does or the other party, and maybe one party never agreed that it was a good idea to begin with, and they want to kind of say public school is okay? I mean, because that can be an expensive part of it.
That's frequently a disputed issue, and you have to have a judge decide. So I had a judge once, this is years ago in Anoka County, where the kids had gone to private school. They were like fifth graders, six, around that age. They had a couple of kids. And so we put in our client's budget the cost of tuition because, to me, they had decided together that was an expense. And Dad said, nope, I don't want to have to pay for it. And the judge said, I'm not going to make him pay for it, right? But another judge might say, well, look, you decided together. We don't want to upset the apple cart. We want the kids to maintain stability. So it's not child support, right? Because that's different. So it kind of depends, but we frequently see that disputed.
Okay.
So
let's talk about some alternatives to a straight divorce or court or lawsuits back and forth.
Right.
They've created, the courts have created a lot of alternatives that help these matters for less money and faster,
Yes.
correct?
Yes.
Do you want to talk a little bit about those?
Right, and I think what you're referring to is something that we call the E&E process. It's an evaluative, a neutral process, and when you are in the process, you might think it looks like mediation. The difference is that it's under the kind of the auspices of the courts, and they will order you into what we call an FE&E, which is a financial neutral evaluation. And the E stands for early. So you do it early on in the case, right? So it's not dragged out. Or what we call an SE&E, a social early neutral evaluation. And you have to check in with the court how you're doing. You have 60 days. The attorneys pick the providers. I have a short list of people who are very good at getting cases settled. And then there's a series of settlement meetings, sometimes financial. Now, in the financial early neutral evaluations, there's typically one person, frequently a very seasoned family law attorney, or sometimes a CPA who works in the divorcing world. Because if you have a complicated marital estate, you might want to have a CPA as your neutral to help you settle. So that's one way. In the SE&E, the social, that's about custody and parenting time. And you have one male evaluator and one female evaluator so that there's not gender bias.
What are their credentials?
Well, usually what I like to do, and it's become, I think most attorneys do, is you pick one of the neutrals is a mental health professional, like a child psychologist, and another is an attorney, so that you have the balance of one of the evaluators knows the law. So if the mental health professional is not aware, the family law attorney can say, no, it can't do that, or that's, I don't think that's, reasonable. But then the mental health provider can say, look, developmentally, a kid that age can't handle it, so they can kind of give you feedback. And so it's a series typically of settlement meetings. And the difference in mediation is that these evaluators are allowed to give feedback. Look, if you go to court, this is what I think your judge will do. And so it's extremely helpful because if I would make the same suggestion, the other side might go, no. Or, you're just more distrustful of the other person's, parties are usually distrustful of the other person's attorney, just by the nature of.
So it's based on their experience.
Yep.
It's sort of predictive of what the outcome
Yes.
may be. It doesn't
Right.
necessarily mean that will be the outcome,
Right.
of course, but it gives you
Yes.
based on their experience,
Yes.
what will happen.
Right. And I have just seen, since this program, and it's been, I want to say 15 years, it could be long, who knows, but at least 15 years, these programs, it started in Hennepin County, and the number of cases that settle has just increased substantially with it. It's a great program.
That's
and you
good.
you get to pick your provider, so I know who I like, who, does good work, and that sort of thing.
Is that the same thing as collaborative law?
No,
or is that different?
That's entirely different. Collaborative law was started, I don't know, about 25, 30 years ago by a family law practitioner by the name of Stu Webb. And he was just kind of worn out with the whole, custody battles and, fights that people were having and the harm to the kids. And so he started a process whereby the parties at the beginning of the case sign a contract that they will not go to court, right? And so they hire professionals, they have attorneys, they hire financial neutrals that work in the divorcing world.
Do they do that through you as an attorney?
Yep. So
Okay, each party still has an attorney.
Yep. Each party typically, there have been cases now and again where one doesn't, but in a true collaborative case, the parties say, we're not going to go to court. And they'll hire, sometimes there's a whole team of professionals, a child psychologist, a financial expert. If if they're mental health issues, sometimes a coach to help the, offline away from the meetings. And so again, it's a series of settlement meetings. And the hope is at the end of the day, what will happen is they'll come to an agreement that can just be sent into the court. And because they're both represented, there doesn't need to be any court appearances. And the theory behind that is, you want to kind of keep more control of your case. You still have professionals who are giving you advice and helping you, but you don't have the threat of kind of court hanging over you. And some people really like that. That makes them feel more secure and able to negotiate and that sort of thing.
Does it work across the board?
No.
It doesn't. So is it based on certain cases or
facts, by facts. So if I have someone and I practice collaborative law, I have many more litigated cases, but I do have collaborative cases as well. And what happens is if a person comes in and says, I want to do this case collaboratively within that process, and it's a method of settling a case, right, outside of what we call litigated, which isn't as scary as it sounds. But I look for red flags because in the collaborative process, you have to be transparent. In the litigated process, if someone is refusing to give me documents, I can issue a subpoena. I can do what we call formal discovery, where the other party has to answer questions under oath. So I know that I can get the information. In the collaborative process, it's based on trust that each party will fully disclose assets. So if someone comes into me and says she hides money, she's got secret account, that, and then I'll say, oh, this isn't a good match for collaborative because she might not be transparent, and you have to have that level of transparency in collaborative. It's a great process, but
is it more where they're amicable to the divorce?
Yes,
and they're not contentious. They don't want to hurt the other party. They want to save money.
Right. They want to be They want to be more careful about it. They still can be tense, right, because the parties are divorcing. But a really good financial neutral often helps a collaborative case and go smoothly. So, as I said, it's a method of settling a case, and they can be highly successful. There's some criticism of it, which I think is valid, in that if you don't reach an agreement, the attorneys need to withdraw and start from scratch. So they have to get new attorneys. And I believe the theory behind that is, if you're committed to this process, we're not going to dink around with it. You're not going to see, can I get a better deal here or a better deal here? This is the method you've chosen. We're committed to it. We're going to, as I said about 6 times, with the help of professionals, we're going to get this figured out. So that was part of when Stu Webb created it. That was part of the thought behind it, that this is serious. It's not just.
How much faster are these things resolved through a collaborative method, all the ones you've mentioned?
Actually, litigated cases can be resolved more quickly because the judge, so at the beginning of a litigated case, you have what's called, it's a scheduling hearing. I look at it as a scheduling hearing, and meet your judicial officer, called an initial case management hearing.
So you have deadlines that you have to meet?
Yes. So you go to that scheduling hearing, and the judge says, I'm going to contact the attorneys, like, what are you going to do? And we'll say, we've selected so-and-so to be our FE&E provider. I like to call the attorney ahead of time and have a plan figured out, so when we go to that hearing, we're not, what are we going to do, sort of thing. So then the judge will say, well, I'm going to schedule a telephone conference call with the attorneys in 45 days to check in, and they really kind of keep the cases moving forward. In collaborative, sorry, my schedule doesn't work. You know what I mean? Like there's no hammer over you. Yeah.
Mm-hmm. So why would somebody want to do collaborative law? What's the large benefit if it potentially could take longer?
I think it can take longer. There's
Are they more
no
in control,
deadlines.
A little bit more in control?
Right, a little bit more in control. Picking their their providers. But it's really kind of a feel like that. Okay,
we're not a good fit.
We're not gonna duke it out. We're gonna get the help we need. We're gonna have these discussions, and we're not gonna worry about a judge. Because I litigate, I think like the E&E process is really great. So I don't get too worked up if someone says I want it to be collaborative and it's not a good match, because the case will get settled as well. But some people really do not want to have the courts involved.
Let me go back on something that you mentioned earlier about child support and county services. Mm-hmm. How does that all connect? So if, about child support, and how do they get involved, and if somebody doesn't pay.
Sure.
And actually, what happens in a situation where they don't pay, and do people ever go to jail because they're not making payments, and how often does that happen?
The judge has the authority to put somebody in jail. You don't see it very often for not paying child support. So what happens is there'll be a court order saying you owe X amount of dollars for child support per month. And let's say someone doesn't pay. And let's say someone doesn't pay because he or she has lost their job. So what they'll do is they can bring a motion to say, can you reduce my child support till I get work again? So that's kind of one way that people can change child support. But when they just outright don't pay, right? The obligee, the person receiving the child support, can sign up for what we call 4D services, and that's a federal code. That's why we call it 4D, that they are entitled to have the county collect the child support on their behalf. So the county can collect daycare, can collect what we call basic child support, and then medical as well.
Collected from
the obligor, the
but
person.
What if they don't have a job? They have no money. Is it sort of a
right? The arrears are piling up,
Okay.
right? And so what happens is that for a period of time, that's when the payer has to go to court and say, look, I lost my job. I want it reduced. And the court will say, okay, but we have we'll set it on for a review hearing. In 3 months, we'll see how you're doing with your job search, that sort of thing. Most people, I have a case right now where our client lost his job, and we negotiated a downward deviation from what he was paying until he found work. So we were able to get that worked out. But the county can collect it. Some of the things that they can do is they can suspend a driver's license.
Does that happen very often?
Yeah, that happens really often.
Do they have to, the spouse who's supposed to be receiving child support, do they have to do something to have that happen?
Yeah, they have to contact the county. Well, if they've already signed up for 4D services, then the county's managing that, right?
Okay.
So they have to be signed up for those 4D services to be able to have the county collect. Otherwise,
is that something the county will take on their own as far as getting their license revoked, or is it something?
Yeah, the county does all that. We'll be in touch with the county attorney working on the case about things, but I think most common is you'll see a driver's license suspended, or sometimes I'll have a potential client that comes in and says my driver's license got suspended because I'm not paying support, but I haven't worked for 6 months. Well, you got to tell someone. You know what I mean? You have to tell someone so that you can fix that. And
so get ahead of it, obviously, is important.
Interesting enough, I just saw this past week, there was a Minnesota Supreme Court reinstatement of attorney whose license had been suspended for non-payment of child support.
Interesting.
So
were they a family law attorney?
I didn't recognize the name. Yeah, so I didn't know. But the obligor had shown that his arrears were all taken care of, and I thought, wow, that's a pretty extreme step. I don't know how much the arrears were. I don't know, the details. It just said that he had been reinstated after being administratively suspended for not paying child support. So,
but some of those arrears just can go on for a long time because maybe it's the deadbeat mom or dad, so to speak, right?
Right. And then what you can do is you can get a judgment as a matter of law. If you're behind, the obligee can ask the county to do get a judgment against that person, and then once you have a judgment, if that person has a bank account, you can attach the bank account. But unfortunately, there are some people who just never pay child support, and they don't work. They work for cash, so the county can't collect through an employer because when the county's collecting, it's often through mandatory wage withholding through the employer. So if you're not working, there's plenty of people who are.
If you have nothing, can't get anything.
Right.
Okay.
Yeah.
All right. Let's talk about this. It may be a touchy subject. Costs.
Yes.
For the attorney.
Yes.
What do people do when they can't afford an attorney? What routes do they go? I mean, just not only is it can you do on a contingency? Is it hourly? Is there flat rates? I mean, kind of explain that process.
Sure. Family law attorneys aren't allowed to do cases on a contingency basis. So most often we do hourly, right? So we have what my hourly rate is. We require a retainer up front, and that will cover so many hours. It kind of secures services. And people often say to me, well, how much is this going to cost? So what I like to tell them is, I don't want to give them a number, because if I say $5,000 and it's $6,000, then they're like, well, you don't want to give them misinformation. So I'll tell them, here's my hourly rate, and here's how much this time this will take. So if we have 2 settlement meetings and they're 4 hours each, right? So take 4 hours or 8 hours times my hourly rate. then there's going to be the gathering of documents. We need to have your 401k statements. We need to, gathering the financial.
It's kind of like an estimate.
Yeah, right. So I try and give estimates of time. If a case is going to go to trial, then all bets. I mean, that's tens of thousands of dollars. And the reason for that is because it's so labor intensive. Not only do you have your days of trial, right? If you have 10-hour days, but the prep is to get your exhibit books, to make copies of documents. It's very, very time consuming. So that's where the costs, are not only the time of the attorney, but preparing for trial.
And that's why a lot of these cases are going towards the alternative methods.
Right, and selling. And most cases settle. I think, 95% of cases they say settle. Sometimes they settle early. Sometimes they settle. There's a process called a moderated settlement conference. And again, that looks like what people would think of mediation. And it's once trial has been set and it takes place at the courthouse, whether in Hennepin County, the Family Justice Center, or Carver County, wherever it might be. And the neutral comes to the courthouse, and the two parties and the two attorneys work all day to try and settle the case. And the difference is that you have this trial hanging over your head, and you don't want to have to pay attorneys to get ready for it. So there's like this, it's different than the beginning where like, let's see, that sort of thing. By now they're like, ooh, I don't want to go to trial. I don't want to take a chance. And so those are they're very successful. I enjoy doing moderated settlement conferences.
Well, I think in all areas of law, settlements are better for all parties.
Way better. Yes, much better.
And, I see settlements as being where a good settlement is where both parties don't think they got the greatest deal.
Right.
Because if one party thinks they got a great deal and the other party doesn't, that's not a great settlement.
Right.
But if both parties feel like a little pain, but feel glad to be finished with it, that tends to go a long ways towards them agreeing to it.
And I've heard judges many times say exactly that, right? It's a good settlement if you both feel like, it's not perfect. And people have to compromise, right? They have to kind of figure out how to compromise. I'm always astounded when people will dig in their heels on certain issues, and I think you're going to pay me more than you should. Just if maybe you're going to lose $2,000 or $4,000 or whatever it might be. Take that hit rather than paying me to litigate it. Have common sense. You want to have a good advocate on your side. You want someone who's going to listen to you and understand, kind of what you're looking for. But my job is also to say you're being foolish, right? Like that, your outcome is not going to be worth it, to pursue this. And sometimes I'll just tell a client, I'm not gonna ask for that. Right. Because they're going to lose, and I just won't. Right.
I mean, it's your job to guide them in the right direction and give them, the best advice you can. But sometimes they'll say, I don't agree, and that's their choice. Right. It's always their choice, right?
Always their choice. And sometimes you have to go to trial because the offer is so unreasonable. I had a case where my client, it was a spousal maintenance case. And the husband, she needed to get back in the workforce, and she agreed that she could be back in the workforce, but she needed a period of time to do so. And the husband said, "No, you go back to work now. I refuse." And he was a high wage earner, and he refused to pay her any spousal maintenance. Well, she couldn't meet her budget because, she had zero income, and even if she immediately got a job, it's not going to be in her field, and so on. So that is a case that we took to trial, and the judge awarded her $8,500 a month in spousal maintenance for 3 years if he wouldn't have been so stubborn and said zero, if he would have said $4,000, she might have taken it. Right. But then
it's up to the judge. Do you have jury trials?
No.
It's just judge trials.
Yep. Okay. You're entitled in paternity actions to have a jury trial. I've never had a jury trial.
Okay. Yeah. Because the judge is more experienced, and there might be too much emotion with the jury. And I suppose it takes a lot longer because you have to pick a jury and the whole thing. So.
Right, exactly. Yep, they're always bench trials.
And how often does a judge you mentioned a little bit about this, but how much do they force a settlement, or do they ever give predictive, issues about how they're going to, sway the case just a little bit to the attorneys at least?
Right. Yes, and so prior to trial, there's a settlement conference or something that's called a pretrial. It's different. It's not the same thing as a moderated settlement conference is right before trial. But in a pretrial, everybody goes to the courthouse and they flesh out what are the issues, what can we agree on, and what we can't agree on. And so it's not uncommon for the attorney to go back in chambers and say, this is what we're stuck on, right? Here are the issues, this or that, and giving information to the judge. You have to be careful. The judge is the finder of fact, right? So he or she can't really say this is exactly what I would do. But sometimes a judge will be really helpful in saying, I just don't see this as a spousal maintenance case, or you'd have to show this. So then we can take that back to our clients and say, look, we've got a feel from the judge that he or she might rule this way. So it's never, this is exactly what I'm going to do, because again, the judge is the trier of fact, and that would be premature for a judge to say. But you can say, they'll give you hints,
And do you kind of have an idea about the different judges? Because they're not going to
Yes.
all be exactly the same.
Right.
How they're going to rule in some
Right.
cases or
Yep.
different cases.
Right. Yes. You after you do this for a while, what judges are more likely to award a joint physical custody, right? What judges might be inclined to say, we don't want a kid moving back and forth. Judges are they pro-spousal maintenance or not pro-spousal maintenance, right? So over the years, you get that experience, and it's just by having case after case, and you get a feel for how the bench thinks.
Can you pick a judge?
No. So you have one strike. So when a judicial officer gets assigned to a case, you get one strike, and then that means the next judicial officer, that's who your judicial officer is. So we rarely strike judges.
Won't they hold it against you another time when you get
Maybe
them?
they might, right? They might. Sometimes we do, because if we have a case and there's a judge who's is extreme on one issue, we'll strike him. Or there have been times where I've had a series of bad orders or orders from a judge that didn't make sense. So I'm like, I don't want to risk this with my client. I'll take my chance with a different judge. You parties can hire what's called a consensual special master, and that's kind of like hiring your own judge. And so you say,
Is it usually an attorney?
Yes.
Okay.
Yep.
Who's experienced in these types
right.
of matters?
Yep. There's a couple that I have used, and so you kind of are. That way, you can pick your consensual special master. I have a case right now. We just got our decision from the consensual special master, and she's a very seasoned family law attorney. And so rather than taking it to the courts, we took it to her. So
like a private court, right?
Kind of, right. But that doesn't happen on a regular basis. We're mostly with the different judges in the different judicial districts.
Do judges have biases towards male or females?
They're not supposed to, right? Right, they're supposed to be justice
they're
is
people.
blind, right?
They're people.
Yeah, right. And so that kind of goes back to knowing your bench. Like if you know someone who's inclined to, do more of a joint
Settlement or type of thing.
Physical custody arrangement. There's judges I can think of that I know for sure they do not like, they want sole physical custody, and they're not gonna, do that. But I don't know, we, talk a little bit, once in a while about amongst colleagues about judges who we think have a certain bend. But generally, judges, I think, try really hard to apply the law regarding custody and parenting time, and to look at the facts, and they'll frequently say, we want to make sure the kids are okay. We want to make sure that everything is okay. I was in court this morning, and the judge showed us, and we were at that scheduling hearing, a photo from it must have been like a training or something that had a picture of a kid, and it said that wherever this training, that living in a violent home, which includes emotional abuse, is the equivalent of being in combat. And that these kids have post-traumatic stress syndrome. And so her point was, I'm telling you early on at the beginning of this case, do everything you can to limit the conflict between the two of you, because studies are coming out now showing the significant harm to children. I mean, to the fact where it's like the equivalent of being in combat, right? If they're in a home that is not only violent, but emotionally abusive. There might be no hitting, but if there's verbal abuse or, that sort of thing.
Does it happen more with younger children versus older children, or it doesn't really matter? When you see problems affecting the children, so to speak? Is it more? Does it affect them more when they're younger,
Yeah.
or old teen years, or?
I don't know. I think that sometimes it's harder for kids if they're older and their parents get divorced and they're taken aback by it. Sometimes kids know and they're relieved that their parents are divorcing because they've been living. People all say, "Well, I want to stay married for the sake of the kids."
That could be worse.
It could be
obviously,
worse, right, for them. It's better to have. I heard a study a few years ago, whether this is true or not, but that it's better for parents to get along, whether it's as a married couple or as a divorced couple, than to have a contentious relationship. It's better for the kids.
Sure.
What matters is the relationship and how the parents treat each other more so than their being in the same home.